You are?
We are the Chief Human Resource Officer at Dish Network.
All four of you are Chief Human Resource Officers?
We're all kind of representative of one individual.
Oh,
So we're
like the four parts of mine.
So, excuse me, we're kind of talking about, this is many faces of Sybil, you're schizophrenic. All four of you add up to one.
A little bit, yeah.
This adds excitement to this.
Very exciting.
Whoa.
It sounds like an HR team.
We'll go with that.
Yeah.
That works for us.
That's less stressful. I think that's good. Okay.
Can we use the clicker? Would that be all right?
That is yours. And what I'm going to do is remind you of what you probably already know, but everybody starts with a clean slate of having to hear this. So you're obviously doing the full presentation, and you've taken on a role, and we have a role you've given us, and we will promise to stay in that role for the time of the questions that we have. You are going to be asked questions. I'll ask the first one, and then Diana will ask the second, Ruth the third, and then we'll go back until we're done with the 20 minutes. We're going to give you feedback outside our roles, and the role of our feedback is really to help you be even more effective tomorrow in your 10-minute presentation. So keep in mind that while there'll probably be tons of things we'd like to pat you on the back on, we really want to focus in on how to zero in on anything that might help you for tomorrow. Please remember that we're not interested in knowing how much you know about deontology or utilitarianism. We don't want those terms. We don't want anything except what you would give to a business group to have them understand and feel connected to what you're saying and not talked down to. We want to remind you that if you read anything, you can use notes, but be careful that you're not reading a text. It takes away from what you're doing. And we assume that all of you have a speaking role. Then we are, if you are, ready to begin. Except that I'm not. Hello. Okay. You ready?
Yes, we're
Okay,
ready.
let's go for it.
Good afternoon. My name is Ellen Claus. This is Joe Duda, Michael Plate, and Meryl Ferry. We're the business ethics team from Marywood University. Today, we will be representing Mike McClaskey, the Chief Human Resource Officer at Dish Network, and his associated team. We will be presenting to you the Board of Directors at Dish Network. We have always projected as one of our core values that we support our employees in the matters that mean the most to them, yet our public reputation fails to project this. In fact, we've been named by multiple sources that we're one of the worst companies to work for. This is not a reputation that we want, nor is it one that we can maintain. So we need to start making changes to how our company treats our employees. We want to begin with an issue that occurred about 1 year ago, when one of our employees was fired for his off-duty use of medical marijuana. To give you an overview, we're going to be discussing Dish Network's current drug policy and propose to you changes that we feel ought to occur. We'll be discussing the legal, ethical, and financial considerations that went into making this decision, and we'll provide you with a cost-benefit analysis that compares what would happen if we implement these changes versus what happens if we keep our policy the way that it is now. Let's give you an overview with what happened at the Coates versus Dish Network case. Our employee's name was Brandon Coates. He was a quadriplegic that took medical marijuana to treat his seizures in his off-duty time. We found out that he was a medical marijuana user through a random drug test. He was then fired for that act. He sued us for wrongful termination, but we won the case because medical marijuana is not protected by the federal government. However, was this the best choice for our employees? Was it the best choice for our stockholders? We feel that this decision was not in the best interest of our company, and we're going to discuss with you why that is.
To begin, we will refresh you on Dish Network's current zero-tolerance drug policy. Dish Network maintains a drug and alcohol-free workplace and requires all potential job applicants to pass a pre-employment drug test. If any employee reports for duty under the influence of drugs or alcohol, or is found in possession of drugs or alcohol on company time or company property, that individual will be subject to immediate dismissal. Drug testing may occur prior to employment, randomly, after an on-the-job accident, or if an employee appears intoxicated on the job. An employee who does not pass the drug test will be immediately dismissed. After evaluating the financial, legal, and ethical implications of our current policy in states where marijuana use is permitted, we have decided to keep most of our policy as it is. The policy considers the safety of our workers and appeals to the stockholders' interests. However, we have decided to make minor changes to be as accommodating as we can to possible future employees. Primarily, we will allow employees to use medical marijuana as long as they are not positioned in high-risk jobs, such as those that have travel requirements, are involved in installation, or operate machinery. We will provide them with reasonable accommodations as is necessary, but we will not subsidize medical marijuana, nor will we allow its possession or use on company time or property. Applicants wishing to hold a job at Dish Network who are medical marijuana users will not be considered for high-risk jobs, but may be considered for other positions. Drug testing will occur prior to employment, after any on-the-job accident, or if there is reasonable suspicion that an employee is intoxicated. We will provide our managers with an annual half-day training session on the signs of an intoxicated employee and how to approach such a situation. Finally, any employee testing positive will be required to provide information to the testing agency on their prescription and when the last time they used this prescription was. If the information is accurate according to the drug test, the prescribed amount is within state regulations, and the employee is not in a high-risk position, then the employee will not face drug-related discipline. If an employee tests positive and is not prescribed medical marijuana, or if the test results do not reflect the proper dosage, then the employee will be dismissed. Our overall aim is to reduce substance abuse, and while this policy may at first seem counterintuitive, we will explain why it will likely reduce accidents and financial costs due to substance abuse in the workplace. We will also be addressing the legal, ethical, and business factors that encouraged us to change our policy.
So as Meryl said, our overall objective here is to reduce substance abuse in the workplace. So we took a look into what kind of harm substance abuse does currently. And what we found is that 40% of workplace fatalities are caused by substance abusers. They're also 10 times more likely to miss work, 33% less productive, and on average, they cost the company $7,000 per year per abuser. Now, 69% of those losses are due to drug-related illness and death. We furthered our research and found that the CDC had produced information stating that in 2013, no one had died as a direct result of marijuana, meaning no one overdosed. However, they also said that nearly 19,000 people overdosed on opioid painkillers and over 10,000 people overdosed on heroin. We included the heroin toll because the CDC had also stated that opioid addicts are 40 times more likely to use heroin and become addicted to it when compared to medical marijuana addicts who are 3 times as likely. We believe that it's not right for us to pigeonhole our employees into forcing them to choose opioid painkillers instead of medical marijuana, and we feel that we have to adopt our policy to reflect this.
Now, here are some legal issues with medical marijuana as we look at various United States federal laws and acts. These laws reflect the base level requirements we wanted to achieve when developing our policy. As of now, there are 35 states that allow for comprehensive public medical marijuana and cannabis programs. However, even within these states, their various laws differ. Some states allow for the use of low THC cannabidiol medication, which can include a pill that provides the medical benefits of marijuana without the associated high. Other states require accommodations for registered medical marijuana users, and they do not take any adverse actions because of medical marijuana programs. For example, the state of Arizona, where an employer is prohibited from discriminating against an employee who has tested positive for marijuana and is a registered medical marijuana patient, as long as the employee does not have a safety-sensitive job like heavy machine operator or pilot. They are protected under the state law. Before I discuss federal legislature, the legal complications that arise from state versus federal laws regarding medical marijuana is that as of now, medical marijuana is still illegal under federal law. As of 2016, marijuana is classified as a Schedule I substance in accordance with the Controlled Substances Act. Other drugs classified in the same category as marijuana under the Schedule I substances include heroin, ecstasy, LSD. and these are all considered by the federal government to have a high risk for dependency and no accepted medical use, making their distribution a federal offense. So, what is the current federal position on marijuana? Basically, the federal government is not going to prioritize the prosecutions of people who are using medical marijuana. However, this does not mean that the Justice Department will completely ignore a federal law that's actually on the books. In August of 2013, though, the United States Department of Justice did make a statement suggesting that the states should create strong state-based enforcement efforts and that they would defer the right to challenge their legalization laws at this time. When examining the case of Coates versus Dish, we found several issues with Dish's current policy, which brought us to where we stand with our proposed new policy. Dish terminated a competent employee who had the experience, education, and skill to perform his job, which he had performed for 3 years. He had never needed to request special accommodations for his medical marijuana usage. He never showed negative efficiency, and his medical marijuana usage never caused a danger to the health or well-being of any other employee at Dish. In fact, Coates was actually ranked in the top 5 percentile of his coworkers, and he was moved into a more prestigious commercial section of the company's department. We believe that Coates' medical marijuana usage should not have been a primary concern of the company, and it cost us an employee with above average qualifications and gave us negative public image. As far as Dish is concerned, potential issues that may arise from individuals who use medical marijuana primarily come up in the Family Medical Leave Act and the Americans with Disabilities Act. As Ellen stated earlier, we provide rehabilitation to employees seeking help, and the reason we do falls under the Family Medical Leave Act. This act allows a qualified employee up to 12 weeks of unpaid leave for their own health condition or to care for a qualifying family member. The FMLA does not permit an employer to terminate an employee for extended absences taken in order to obtain treatment. The Americans with Disabilities Act prohibits employers from discriminating against those who are disabled and those associated with a disabled person. It requires that employers provide reasonable accommodations to the disabled employee so the employee can perform the essential duties of their job. It also affords certain protections to employees and applicants with disabilities, such as the confidentiality of medical information. Additionally, this act places restrictions on drug testing, where the decision to test must be job-related and necessary for business, as well as conducted when there is evidence of a safety or job performance issue. When Coates was terminated, he wasn't fired because he didn't meet the criteria under the Americans with Disabilities Act. He was fired because of the stigma that surrounds marijuana. In the end, according to federal law, we're not necessarily required to forbid the use of marijuana, nor are we required to permit the use of it as a reasonable accommodation for a disability. However, that doesn't mean we shouldn't. What we propose is a policy that provides various reasonable accommodations nonetheless, especially when the employee satisfies the job requirements, has the experience, education, and skill. While this isn't directly required, it more than likely will be soon, and it's still in the spirit of the law while we're still maintaining an ethical standard for our employees.
So Mike just gave you the legal considerations that went into our policy change, and I will be talking about the ethical considerations. So first, let's look at our current policy and see how we believe it's harming Dish Network. We believe that our current policy is coercing our employees into using a much more harmful substance as opposed to an alternative which we've been denying them, medical marijuana versus the opioid painkillers. We're creating an environment of mistrust and aggression with our random drug tests, where our employees are always on edge or in fear of what might happen for their autonomous choices. We feel that this is in conjunction with the coercion hurting our employee morale and productivity, and we feel that in order to recoup our public image, we have to address and adjust these issues. So the ethical dilemma here that we try to address is how do we balance workplace safety and medical privacy? So what we did first was look at the goods of autonomy. And what we find is that, well, first let me define autonomy. Autonomy, we're defining here as the power of an individual to act independently according to his or her own personal beliefs without coercion or exploitation of any sort. We believe that this is intrinsically good and is an empowering device for our employees. So why is autonomy intrinsically good? Well, to be autonomous, briefly, is to be one's own person. This enables diversity and all the key benefits that come with it: outside-the-box thinking, creative thought pools, and solutions to problems that typical non-diverse workplaces might not come up with. We also believe that being autonomous enables employees to be intrinsically motivated, which is just being motivated in order to do something for the sake of doing it. And we believe that this kind of motivation is the kind of workplace, we want to see this in our workplace. We want to see our employees being empowered in this way and working harder so that we have a friendly, sustainable environment. We believe that disrespecting this kind of autonomy would take away all these benefits that we'd be gaining, and we feel that we can't sustain that for very long. However, we understand that under certain circumstances, for safety, we have to restrict certain autonomous decisions. We believe that the autonomy of someone can be restricted if it's going to infringe on another's safety or hurt the company itself. However, this comes with some reservations. There's a difference between restricting autonomy and repressing it. We believe that restriction is objective and for the good of the company and all its employees equally. It fits a fair criteria and is the same across the board. Whereas a repression is acts of restriction with bias inside them. We believe that the choice to not allow medical marijuana is more repression than restriction, mostly because of the stigma, and that we haven't found any evidence to suggest that it's any more harmful than opioid painkillers, which we tolerate now. And we believe that this is a result of biased reasoning. So it's for this reason that we're choosing to keep pre-employment drug screening as an act of restriction, and we're in the interest of workplace safety, but we will not be keeping random drug testing.
Now, there's something to note about Brandon Coates' firing. We found out that he was fired through, that he was a medical marijuana user through a random drug test. This is a significant fact and one that has been most influential in changing our policy. We feel that this was a severe act of violating medical privacy. And while what we did was certainly within accordance of the law, what we did can be demeaning to our employees and their empowerment. When we speak of medical privacy, we're referring to an individual's right to control personal information about him or herself and the situations over which such a right may be extended. If we wish to obtain such private information, we have to consider its relevance. If we can justify looking into someone's personal life at something that doesn't affect their work performance, then we would also be justified in considering their religious affiliations, sexual orientation, their marital status. These are questions that usually an employer cannot ask of their employee. So what information do we actually learn from random drug testing? We don't find out I apologize. By random drug testing, we're really violating an individual's personal autonomy. We are allowing our employers to regulate an employee's behavior outside the workforce, which ought to be outside that employer's sphere of control. But what do we actually learn from random drug testing? It doesn't measure their performance. It doesn't measure their qualifications. What it does do is an unjustified loss of privacy. It's damaging to their reputation. It can cause emotional distress, and it breaks down the trusting environment that we want to build here. We suggest other treatments for this, such as having education, training, and medical treatment if needed. Really, we want to ensure that by having privacy, by having autonomy, we're allowing our employees to have intrinsic motivation, which will lead to an empowered workforce. Why does an empowered workforce matter? Because of the 2 million individuals who quit their job every year in the United States, 40% of those are due to a lack of empowerment. These high turnover costs can be very costly to a company, and that needs to be a focus for us. So overall, what have we discussed here is that we want to have an empowered workforce, and to do that, we need to maintain our employees' autonomy, and we need to maintain their medical privacy. Now, there are many ways to do this, but as we said, we need to take one step at a time. And so, to change our policy, we want to allow the off-duty use of medical marijuana, and we need to remove random drug testing from our policy.
So first, I would like to discuss what we stand to gain by changing our policy from one of absolutely no tolerance to one that allows for use outside of the workplace. This move would help Dish Network be seen as an empathetic and tolerant company, which considers the health and safety of both its customers and its employees. The option to treat their ailment as they see fit within the boundaries of the law and not to have to worry about how this choice affects their career empowers the employee. And studies have shown that there's a direct positive correlation between employee empowerment and efficiency in the workplace. In accordance with our policy, we will allow medical marijuana use but not subsidize it. This will save the company a significant amount in medical costs, since employees who would have previously been forced to use subsidized painkillers will now have the option of this unsubsidized treatment. This approach will also save the company in paid medical leave for our hardship cases. One example of a hardship case employee is a woman with breast cancer. As Mike mentioned earlier, under the Family Medical Leave Act, we must allow an employee at least 12 weeks of unpaid leave for medical purposes. On average, women treated for breast cancer with surgery and chemotherapy misses 40 days of work per year. Treatment with medical marijuana cut these absences down by at least half, saving the company an average of $5,000 per year per employee. If we do not revise our policy, we stand to severely limit the pool of eligible employees from which we can pull as individual states legalize medical marijuana use. This move will decrease employee turnover within our company. A recent study showed that on average, 4% of Americans who are drug tested for employment reasons fail. This means that out of your nearly 10,000 employees who are drug tested per year, approximately 400 of them will fail a drug test and subsequently be fired. Of these 400 employees who fail a drug test, 23% of them will have failed because of marijuana use. This is nearly 100 employees failing because of marijuana use per year. On average, it costs 38% of an employee's annual salary to replace her. Let us assume that the average salary for a Dish Network employee is $50,000 per year. The cost of firing and replacing 100 employees costs approximately $1.9 million, due to the costs of interviewing, hiring, and training replacement employees, to say nothing of the cost of the loss in overall productivity due to the blow to morale, and the time required to assimilate a new employee into the company. Eventually, if the United States were to fully legalize medical marijuana and the FDA were to approve the drug, we would be forced to revisit our policies to avoid discrimination charges under the Americans with Disabilities Act anyway. In a cost-benefit analysis of the new policy versus the old policy, we see that ultimately if we do not change our policy, we stand to lose up to $3 million due to the costs associated with litigation on the state level, firing a substantial number of employees per year, and the cost of random drug tests. This course of action offers minimal benefits, since the increase in productivity can only be predicted for workers who currently use marijuana and subsequently quit. On the other hand, if we do change our policy, we see significantly lower costs associated with drug testing and the counseling that we will offer to any employee who seeks it. We also see a large financial benefit in allowing our hardship case employees to use medical marijuana. Ultimately, we think that the benefits and moderate costs associated with changing our policy greatly outweigh the minimal benefits and high costs that we stand to incur from opting not to change our policy.
Now we've thrown quite a bit of information at you, so just to review that, what changes are we actually making here today? We wanted to look at a way to make our workforce more empowered. We can't do this completely in one step, but we can take one step at a time. Today's step is to change our medical marijuana policy. We want to allow employees who are not in high-risk positions, as Meryl had stated earlier, to use medical marijuana in their off-duty time. We will give them reasonable accommodations as is necessary, and we will no longer be random drug testing. These three components came from looking at what are the laws right now, what kind of ethics surround our company and our employees, and what are the financial status of changing this policy. With those three things together, we feel that these 3 steps are the best way to move forward and create a more welcoming environment. Thank you. We're happy to take your questions.
Thank you. All right, you want us to reset your timer for 20 minutes? As a board member, I'm really concerned about how we can avoid the mistakes, the potential harm that comes from people coming to work, whether it's medical or non-medical marijuana. It seems to me that a distinction has been removed here, and I'm concerned about the implications of all of that. Can you clarify for me?
Absolutely. So what we had kind of talked about a little bit earlier, discussed, was when do we want to drug test? And that happens if it appears that there's an employee intoxicated while on the job, if there's an accident, if there's a reasonable suspicion of an employee intoxication. And so if an employee should come to work under the influence, they would be randomly drugged, or they would be administered a drug test. That employee is asked to supply to the drug testing agency information on their prescription and when the last time they took it was. Now, we provide them reasonable accommodations as is necessary. It takes about 45 minutes to come down from a high, so they should know beforehand that if they need to take a dose before work, that they need to do it with enough time beforehand that they can take it, safely come down from the high, and safely drive to work. Now, if that employee takes it in a smaller frame and they are intoxicated at work, even if they're a medical marijuana user, then we would have reason to fire them.
We also have in our policy that we will be training the managers so they can be able to look out for signs and symptoms of people who might be under the influence at work, which helps to catch those who are not using recreational marijuana and might want to try to sneak it into the workplace. But by having our managers trained, they'll be able to catch and see signs where they'll be able to hopefully prevent it.
What are our competitors doing? I'm concerned that in proposing a policy that is going to be very welcoming to marijuana users, we're going to be attracting that element of the population, which may in the end not be in the employee population, which may not be to our benefit.
Right. So right now, as you asked, there are only 20% of companies accommodate medical marijuana. 85% of Americans approve of medical marijuana. What happens? Would we be attracting employees who are medical marijuana users? Our concern is about having the most efficient workforce. If we're attracting people who want to apply for a job, maybe medical marijuana users, but are the best professionals in their field, and that medical marijuana does not affect their work performance, then that's okay, because now we have increased our employee efficiency by widening the pool of applicants.
Also, just overall, I don't know exactly like other networks, but a lot of companies have phased out their random drug testing. So personally, I work at a bank, and they reserve the right, but they don't actually do it. Dish Network currently randomly drug tests 50% of their workforce per year. So they're on a much higher level than most other companies are, as it is.
Okay, so you sort of lucked out because I will stay with you guys afterwards. I was the lead employment law judge for downstate New York, and I'm now on the management side representing employers. I write these policies every week, and the reason I turned on my device is because you should know that on Tuesday, the Western District of Washington, the federal courts, have ruled that the employee's failure to participate in an interactive process in good faith is fatal to an Americans with Disabilities Act claim. So I litigate the ADA in federal court and have 3 cases going right now. So this is absolutely fascinating. Somebody here said that after the definition of autonomy, that preemptive screening is a restriction, and analogized that to asking about religious affiliation or marital status. Religious affiliation is protected under the 14th Amendment of the Constitution. The right of privacy, which I wrote my doctoral dissertation on, is a penumbra of 14th Amendment due process, and some judges, like the late Justice Scalia, would tell you that it doesn't even exist and never should have existed. So my question to you is, Dish Network, a lot of people go out and they install, right?
Right.
Okay, the installer climbs onto the roof.
Yes.
The installer is handling electricity.
Absolutely.
So per se, is that not safety sensitive?
Yes, so one thing that we said is that we only allow this for people who are not in high-risk positions. High-risk considers travel requirements.
What percentage of your...
Anybody who's working, operating on a computer screen, anybody who's inside. So obviously we cannot make this accommodating for all, but for anyone who is reasonably accommodating.
So now your employee says, I install dishes, and it's not terribly intellectually driven job, but it's also not being alignment for Verizon either. And you've just given carte blanche to everyone who sits in the office, namely females, for the most part, to use medical marijuana, not to be randomly tested, etc. But the men who tend to be out on the field and who do physical work, who are more likely to have an injury in the course of their career that warrants the use of medical marijuana,
Right.
somehow we're being discriminated against.
No, you are not being discriminated against. We are balancing personal autonomy with workplace safety. This is the necessary constraint that we need to put. We will happily, if the ability is there for us to train someone to fulfill another job, we would love to do that. If the ability is not there to train someone, then we cannot hire that person. It's simply a matter of workplace safety, as you said. It's not discrimination that the fact that more men happen to be out in the field and that more women happen to be inside. We are merely allowing that the people who fulfill these jobs can use it because they're not creating a danger in the
Let me
workplace.
ask you one more question. Where did you get this 40-minute number from? Because the metabolite stays in the system for 30 days.
Right, so we're talking about the high, the associated high that is comes with that. So is there THC in the system? So we looked into what are doctors prescribing, why are they prescribing it, what are companies who are allowing medical marijuana to do, so we're researching just what are typically the associated symptoms with taking medical marijuana.
Can I take it in my lunch hour?
So one of the reasonable accommodations that we've discussed would be if you have a lunch hour and you have a break, we might put those together so you have a 2-hour period to leave. You might come in half an hour early, leave half an hour late, but that would give you time to leave the campus, take it, come down from your high, drive back. These are the accommodations that we can provide. They're reasonable accommodations. If they don't meet the employee's requirement, then again, they would not be allowed to work for us or not be allowed to use medical marijuana.
So I'm driving, but not on your time, I'm driving on my time.
But if you're an employee who wants to use the medical marijuana, wouldn't that be
But isn't it not want, but needs to, the
Needs.
same way you need to take?
Prefers to use this medication.
A medication?
Needs to, we're assuming that there will be a place that you can go within 15 minutes to
Starbucks?
take this. Possibly. No, obviously not. But
Why not? It could be legal in the state.
it could be.
Maybe.
It absolutely could be. They may have smoke huts for it in certain states. Maybe Colorado does. But as far as driving under the influence, we are trying to prevent that.
If you were to, in a nutshell, give me 3 issues that encapsulate your ethical argument, would you just clarify and repeat for me what are the most important things that you're asking us as a board to consider from the standpoint of the ethical considerations?
Sure.
Top 3.
So the top 3 would be, number 1, opioid painkillers are more harmful than marijuana, or at least that's what our data suggests, as of right now. There could be more data later, but we'll deal with that as it comes. So the opioid painkillers, which are legal by the FDA federally, are more harmful than medical marijuana. We saw nearly 19,000 people dying from prescription painkillers a year. Whereas opposed to medical marijuana where there are 0. So our first big ethical consideration is we're forcing people to put themselves in harm's way to keep position with us. And we don't feel that is in our realm of power to do that. Our second is medical privacy. We don't think that random drug tests are an efficient way to tell if you or I are being efficient. If you can take an opioid painkiller and do your job wonderfully without any accidents, then great. The same should be with medical marijuana. If you can take it and there's no negative effects on your work performance, great. If it does affect you, then we would deal with the inefficiency, not the drug. Where our consideration is how are you acting at work and how is it affecting us? We're not so much concerned with dismissing someone on the way they want to treat themselves. And thirdly, we're trying to find a safe way to do that. So this is why our high-risk employees aren't allowed to partake in medical marijuana, and I believe they're not even allowed to use opioid painkillers if they had some sort of ailment, that would harm them, or not allow them to perform their job. They'd have to be relocated or reassigned. So overall, we're trying to show that we're part of the problem with substance abuse. We're forcing people to take a super harmful substance as opposed to, for some of our employees, another option. And we don't want to be dictating who takes what. We want our employees, because we trust them, to choose what works for them and what they feel most comfortable with. Now, if that affects work, that's our concern. But if it doesn't, then we have no business in it.
Okay, so if I understand you correctly, you're really talking about personal harm, avoiding discrimination, and you're talking about changing the word of empowerment that was used earlier. I'm just trying to get a read on the ethical aspect of this. No random drug test. Is this respect? Is this fairness? What is it that you're ultimately trying to accomplish here in our workplace?
So respect for privacy and respect
Right.
for autonomy,
Right.
and allowing them to the best of our ability without discriminating, without a good reason. We feel that we'd be repressing our employees if we say, hey, look, you can't use medical marijuana. You're just going to have to take an opioid painkiller for your problem, when that person may be aware of the statistics, or maybe perhaps the medication makes them feel ill or unable to perform their job. We want to stay away from that, respect their choices as an individual, and allow them to have the benefits and consequences that come with that.
Okay, thank you.
I'm concerned about your recommendation that we scrap random testing completely. If what you're trying to do is to recognize the preference for marijuana over opioids, and there's certainly a lot of support for that opioids have become completely out of control and are really harming people. If we get rid of random drug testing, we're not going to detect opioid use. We're not going to detect other recreational drug use. Let's leave medical marijuana aside. We're not going to detect recreational marijuana. We're not going to detect what could be some really, I'm sure you've read the cases, some really, really harmful substances out there in employees who can go a certain period of time and look like they're actually performing. Because no matter how much you train supervisors, they've got a lot of work to do. It cannot be their main duty to go out and try to figure out if somebody's high on something, and if so, what is it? So why would we, doesn't that simply tell people that we're not serious about our drug policy at all? Leaving medical marijuana aside, doesn't it tell them we're not serious about the remainder of our drug policy?
So I think, I don't know how often it is that a random drug test is conducted the day of an employee coming in high, and I feel like it's a bit safe to assume that if they were doing it repetitively, a trend would be picked up by a supervisor. At least that's what we hope. If it was affecting their workforce or their work ability, I feel that severely to the point of injury or otherwise, it would be detectable in behavioral patterns or something like that. What we're doing with removing the random drug screening is that we feel that most of the times the drug screening shows that you have used it but not when, or how, it shows you when, but it doesn't say you're high right now. It says you've used marijuana in the past 30 days or so.
So why not tailor that policy and say we're going to continue the random drug testing, and every time it shows heroin, we're going to terminate. Every time it shows marijuana, we're going to take a look at when that was ingested and whether there's a prescription for it. Wouldn't that be a better way of approaching it instead of just scrapping the random?
I think ultimately what we're trying to do with this policy, we're not so much trying to encourage them to use marijuana over opioids, we're saying that it's not our business. Until the point where it affects our company or our operations, they can use whatever they want realistically. Not to the point where we're not so much in charge of keeping people from harming themselves. That's their own choice, and until it comes into the workplace.
But at the same time, Ruth, I'm sorry.
Oh no, that's okay.
Well, just one quick follow-up on there. We're also responsible for the cost of ensuring the health of these people. And so do we really not care about, do we really want to support their autonomy to the extent that we're going to support them hurting themselves and affecting their health?
So there's actually, I just want to put this in there, there's a trend starting to happen in states, legislator, which hopefully you can support me on, but that states all have regulations on what kind of drug testing can be performed in the workplace. And there's a trend starting to happen where random drug testing is being removed. And there are several states where random drug testing is not allowed. And so there are reasons for this, obviously, autonomy, privacy. But like you said, we want to balance workplace safety, and so that is a huge concern for us. But overall, we can't be such a horrible company to work for anymore. We need to find a way to respect our employees. If you can look at an employee who has PTSD, who has cancer, and you can honestly say to them, no, you cannot take the medication that you want to take to treat that. I'm sorry. I don't feel that we have the right to say that.
But what you're doing is you're substituting an empirical test, because I've tried cases involving the chain of custody in order to make a decision that's adverse to an employee's job status. And yet you say we want to validate privacy and autonomy, but yet you get a supervisor, and believe me, I don't think Dish Network supervisors are licensed physicians, psychiatrists, drug counselors, or anything of the like, and that supervisor doesn't like how emotional you are, my dear, and says to you, no, I think it's wonderful, okay? And that supervisor just doesn't like you and doesn't like the color red, okay? And says, you know, I think she's acting strange. She might be using marijuana. Where are they deriving this from? Inside their own little brains. She lives in a neighborhood where they sell it, okay? Where there's a dispensary. And you just now, by taking away this sort of objective process of the drug test, now you're empowering the supervisor who could try to use this for their own personal animus. And now you've personalized something. And that part of the policy disturbs me tremendously. Why are you vesting that kind of power in a supervisor who lacks medical training? And by the way, taking one of my courses is not medical training. And so why is that in there?
We had considered this as a possibility, a huge flaw, and this disturbed us as well. And what we would have is when a supervisor, let's say, is suspicious of someone who is intoxicated, let's say, they would, they could pull them aside and either, submit them to a drug test, but they would have to also corroborate their story with a peer of the employee is under suspicion.
What does that mean, corroborate with a peer? Did he hiccup?
No, it would be.
I'll tell you why I'm asking this, because multiple sclerosis in particular shows symptoms that can look like inebriation. Okay? And so the person might be slurring their words. They might be walking, ambling more. They may seem to have a balance defect. And the truth is, what they have is a medical condition. They're not taking any drugs of any kind. And now the supervisor degrades them by having a dialogue about whether or not you're on drugs or you're on marijuana. Where frankly, if the issue is a medical issue, putting aside all drugs, it's none of their business under the Americans with Disabilities Act. And that's not what I would call an accommodative dialogue. It's very accusational in nature.
In that type of a situation, unfortunately, I think we would have to end up sending them for the drug test, whether the supervisor was being unreasonable, if they were corroborated.
And that makes you a really good place to work?
Not particularly, however, we are hoping to become a good place to work. But as far as that situation would go, we would not be made aware of their medical condition, because that drug test is then sent to a third party. And all we get from that third party is, no, they were not on drugs, or yes, they were on drugs.
You get a positive or a negative?
Yes. And that's all we get from that third party. So if no, they were not on drugs,
do you know that if you're taking a drug for a medical purpose and it's legal, it gets reported as a negative? Did you know that?
I did not.
That's the reporting. That's the law.
Interesting. Okay.
Or it may get reported to HR with the reason.
No, we can't. It's illegal. They actually report it because a medical director telephones the individual and says, not regardless of what you put down on the form, because there might be pressure and you might be so upset at taking the test, there's a telephone call, and if you say you have a condition or you say you're on medical marijuana, what they will do is they'll ask you to sign a release, and they will contact your physician, verify that you're on the drug for the correct purpose, and as a result of that, the report will be a negative. There are also drugs that test certain medications will create a positive test for the metabolite, even if you never take marijuana.
Okay, thank you. That's good, thank you.
I'll tell you more.
Yeah, please.
It's fascinating stuff.
So 10 minutes, let's see. I wonder how many years I'll have to do this before I, oh my God,
This is the real challenge here.
before I really get a grip on this.
We just need new devices.
iPhone would be.
Yeah,
Yeah.
well, iPhones fade out. All right,
That's true.
this is feedback designed for tomorrow, for the 10 minutes. You chose a really rich, complicated, and debatable. I mean, you chose something that there's no uniform policy, and so you chose something that's not disruptive, but you chose something trying to break through to create something, and I really respect that. I wish you had done more to connect the horrible company to work for,
Right,
statistics, with some facts. Are there any surveys that were available that said there was a cause and effect between drug testing and being a horrible place to work?
I would say there's definitely a connection between having, was it drug testing and being an unempowered, random drug testing and having an
The
unempowered.
problem with unempowered though, and you mentioned that and I totally bought that, but you're gonna have a hard time in 10 minutes without sounding pie in the sky,
Right.
unrealistic. Everyone's searching for empowerment. How do they
Yeah.
empower their people? So if you can think about another way of bringing that down to a more manageable level so that you don't sound too idealistic without a way to
Right,
to deal with that. I asked you the question about the top ethical issues because even though the whole thing is about ethics, I was having trouble kind of holding on to the most effective way tomorrow you could present and handle that subject and do whatever piece of it you want
right.
that is effective. And Ruth probably has some really good suggestions afterward for you on the whole notion of how you might get around some of the gaps that are a part of this. I think you presented well. I think it's important tomorrow to really understand that you are trying to persuade. And so the language you use, the facts you use, and how you tie it to what you know is business self-interest, that could be attainable and proved by what you're trying to suggest, is really important. If you have any other research about people who have not done the drug testing and have shown an improvement in employee morale, because there's a lot of downsides, and this can probably be debated.
Yeah.
But at least if you present the kinds of outside information that would allow a board of directors to take you seriously and go to the next step, I think you would really put yourselves in a strong position tomorrow. And that's.
And a couple of, first of all, you're all terrific. You're all very polished. You all clearly know what you're talking about and feel very strongly about your position. And that comes through, and it comes through in a very professional manner.
And a positive.
Yes, in a very positive way. And so I'm going to give you some really on-the-ground stylistic things that came to me immediately. I present a lot to my boards of directors. I've been with a number of not-for-profit companies, as well as president of a for-profit company. And I have a long history, an old history of employment litigation, but that's way ahead of things. So I've done a lot of this drug stuff. But you never tell the board of directors, unless everybody has quit and we have a new board of directors, which I think one of these scenarios has. You never say, we have a terrible company and we have a terrible reputation. You don't say that. You can say that the newspaper says that. You can say that the survey says that. You can say that you, the board of directors, have directed us that you want next year to be in the top 20 in this town, this little tiny town or something of 25 employers. You can put it a lot of other ways, but this is our company. Okay, we don't own it, but we are completely responsible for its governance, so don't start out by insulting. And that's something that I think would not come instinctively to you until you've been in that position. And the second stylistic thing is, you haven't made a decision. A couple of you said, I'm not sure who it was, we've decided to go this way because, and it was persuasive as far as an argument goes. We make the decisions. You're making a recommendation. We feel strongly that it's in the best interest of this company too, as opposed we've decided we need to scrap random. Okay, so those are just kind of stylistic. But I think important, yes, since you set this up as a role playing and you do it differently if you're coming in, if you're presenting to HR, your consultant's presenting to HR, it would be a different story. But these are board of directors, and remember, even assuming that Dish Network is a very ethical company, let's assume, I don't know, I have no clue, I have cable. I don't think much of them, so the Dish is probably more ethical, but the board of directors, all they care about, their responsibility is we need to be profitable, we need to be safe. I think what you could hammer on a bit more, because in the back of my mind is I don't want to be sued, as she said, I don't want to be sued for somebody who fell off of the roof of a house or something. You need to hammer on, and I think it's a weak fact that you have a lawsuit that you won.
Yeah.
Okay? So why don't we just keep winning lawsuits? And why don't we just keep all those druggies out to the other companies? You got to kind of work on that and really work on why it's in our self-interest to do this. And the answer to the board of directors, the answer at the university is because society would be a better place. And I'm totally with you. But the answer to the board of directors will never be because society is a better place and a for-profit company. It's got to be because we need retention. Things that you did hit on, you've got it there. I just want you to bring it out more. We need to retain people. We need better jobs so we have better productivity. We need to stop wasting time and money on this random tech. Go through those kinds of really down in the bolts. Remember that you're talking to people who have that fiduciary obligation to money.
And they also do for reputation too.
And for
They
reputation,
also care about the reputation.
And so in that sense, you might want to just bring out more, and I think that was your suggestion, more commentary about the company and why the reputation is so.
Right.
And if I can make one last comment, it wasn't quite succinct enough to me. I liked all the points you made, but it'd be nice to, instead of telling us theoretically what are the topics you're going to cover, if you could say, we're going to recommend scrapping random drug testing. We're going to recommend keeping initial drug testing. We're going to recommend that we treat marijuana different than other drugs. Something really concrete, figure out what the 3 points are, and say that in the beginning, and then tell us why, and then finish up with it.
And keep in mind it's ethical. This piece of it is ethical. So tie those to the ethical implications of each.
And you've got to do that faster obviously the 10 minute. I mean, you had enough time to go over that whole first read. I was eating that up because, I go through this from A to Z, and I thought you did that very well. I have to say, when you were talking about autonomy and defining autonomy, I thought you were right on the edge of violating the Tom White rule of all time, which is do not use philosophical lingo. And I thought autonomy in that sense, if I take it in the context in which it was offered, I really said to myself, oh my God, is Tom going to think this is over the line? Because that's a crucial element of scoring here. So I think you have to be careful with that. This is, when you deal with these issues, they look very simple as compared to other legal issues, but only on face value, because they are not.
Right.
And as you have learned, they are very, very complicated. Most employers who have given up on their random drug testing policy, you should know, are employers which have a very large set of employees governed by collective bargaining agreements. And this is an issue that unions are pushing for. When you have a non-unionized employer, the policies tend to remain. The first case I ever tried involving this involved New York University and the security guards in the dorm. So they weren't touching wires, they weren't on the roof, but they had students in dorms. And part of the allegations were that the security guards who were using marijuana, this is not the medical type, were also selling it. Okay, so there was this, but that, there was a question, are they safety sensitive? They're not RAs, they're not allowed in the door, they're stationed outside the dorm to look for suspicious activity. Meanwhile, they were engaged, and believe me, there was videotape for hours showing the transactions, involving the students. So that's, that was the first thing that I thought of. And one of the first cases I tried 5 hours of testimony to establish the chain of custody. Okay, because they were all fired and they sued the university in a class action. People who are out installing dishes and people who were security guards in university tend to be minorities. Okay, and so then you get into an issue of, that's why I asked the question about the ladies working in the office versus the people in the field. If you have black males installing dishes, and black males comprise the largest single body of unemployed in this country, when you stop a random drug testing policy, one concomitant of that is you're more likely to have employment for certain minority groups. So that there's a political end of this too. But I think given the complexity of the subject, I think you did a very good job.
Do you have questions of us? I mean, what we care about is that you have what you need to go into tomorrow focused on, and you know, I'm just going to read it to you, just so that it's clear. I'm sure it is. Of course, it would help if I found that. All right. So tomorrow, you're going to be told at the beginning of the 10 minutes. You're going to be told you have been called back by the company you gave your full presentation to yesterday for a second visit. They've asked you to speak only about the ethical aspects of the problem and to explain why your solution successfully handles any ethical issues. You will have 10 minutes. There'll be no Q&A. You can't use slides or video. So keep that in mind as you think tonight about what's the best that you've done and said. What feedback did you get that allows you to apply that to have your 10-minute presentation fit that bill perfectly? Make sense?
Very well done. Good luck.